What can we expect from the David defense team? How will they challenge the prosecution's evidence? What will be the defense for the serious charges of murder and sexual abuse and mutilation of human remains when it comes to the death of 14-year-old Celeste Rivas Hernandez? He is represented by a very high-powered attorney. What can we expect? Let's talk about it.
Built around silence. But David Anthony Burke's defense is pointing to one sentence that could shape the entire courtroom fight. They say the evidence will show he did not murder Celeste Rivas Hernandez and was not the cause of her death. That is the line the defense wants the public to remember. Not that nothing happened. Not that the discovery was not serious. Not that the case is not disturbing. But that a disturbing discovery does not automatically prove murder. And now, as the preliminary hearing moves closer, the courtroom battle may come down to one question. Can prosecutors prove Burke caused Celeste's death? Or will the defense argue the evidence only proves what happened after she was already gone? Before we go deeper, like this video and subscribe to True Crime Greyson. This case is active. The charges are serious, and every detail must be handled with facts, not rumor. David Anthony Burke, known professionally as d4vd, is facing some of the most severe charges a young celebrity defendant could face. Murder, continuous sexual abuse of a child under 14, unlawful mutilation of human remains, and special circumstance allegations that raise the stakes far beyond a normal murder prosecution. Prosecutors allege lying in wait. They allege murder for financial gain. They allege murder of a witness. Those special circumstances matter because they can bring life in prison without parole, and possibly the death penalty if prosecutors decide to pursue it, even though California has a moratorium on executions. Burke has pleaded not guilty. That must stay clear. He has not been convicted. The prosecution has made allegations. The defense has denied the central charge, and the court has not decided the case. But the evidence described publicly has already created one of the most intense legal fights in recent celebrity true crime history. Celeste Rivas Hernandez was 14 years old. She was not a headline. She was not a piece of evidence. She was a child whose life ended far too soon. Her family lost a daughter, and everything that now happens in court sits on top of that grief. That is why this story cannot become only about celebrity lawyers, defense strategy, or courtroom tactics. The legal battle matters, but Celeste matters more. The prosecution says Burke and Celeste were connected long before her remains were found. They allege that the relationship began while she was underage and became part of the motive. They say Celeste threatened to expose him and damage his music career. They say Burke invited her to his Hollywood Hills home on April 23, 2025. They say she arrived and was never seen alive again. They say he later tried to cover up what happened. The defense says the evidence will show he did not kill her. That is the battle. One side says the evidence forms a complete timeline. The other side says the state has not proven the most important point: cause. Who caused Celeste's death? That is the doorway into the defense strategy. The prosecution has a powerful story, but a powerful story is not enough. In a courtroom, every part of that story must be supported by evidence. The defense does not need to prove what happened. It needs to create reasonable doubt. And the first place the defense may attack is the autopsy. The medical examiner ruled Celeste's death a homicide caused by multiple penetrating injuries. That finding is serious. It gives prosecutors a medical basis for the murder charge. But the defense may focus on the condition of the remains and the limits of the examination. Public reporting and legal analysis have highlighted that the examination was affected by extensive post-mortem changes. That is the kind of phrase defense attorneys look for, not because it erases the finding, not because it means the medical examiner was wrong, but because it gives the defense a place to ask questions. How much could be determined? How exact was the timeline? How certain was the cause? Could another expert read parts of the evidence differently? Can the prosecution prove the injury occurred exactly when and where it says? Can the prosecution prove Burke was the person who caused it? Those questions do not prove innocence, but they can create doubt, and doubt is the defense's goal. A jury does not need to believe every defense theory. It only needs to question whether the prosecution proved the case beyond the required standard. That is why the autopsy may become a courtroom battle between experts. The prosecution will likely say the medical findings support homicide and fit the timeline. The defense may say the medical findings are limited and cannot carry the case alone. Both sides may bring experts. Both sides may ask jurors to trust science. Both sides may use the same report and argue different meanings. That is how trials work. The prosecution sees a medical conclusion that supports murder. The defense sees limitations that create doubt. The second defense target may be the murder weapon. As of the public reporting available, no specific weapon has been presented in open court as the final proven murder weapon. That matters. If prosecutors cannot connect a specific weapon to Burke, the defense may ask how they can prove exactly what happened. What object caused the injuries? Who had it? Where was it recovered? Was it tested? Was there DNA? Was there a fingerprint? Was there a purchase record? Was there surveillance? Was there a witness? If the prosecution has answers, those answers could become powerful. If it does not, the defense may argue the state is asking jurors to infer too much. Again, this does not mean the prosecution has no case. Many murder cases proceed without a recovered weapon. A weapon is helpful, but not always required. A case can be built from circumstantial evidence, digital records, physical evidence, motive, opportunity, and conduct after the crime. But the defense will still use the absence of a publicly confirmed weapon to raise doubt. The third defense target may be the most important: the difference between murder and post-death conduct. Prosecutors allege that after Celeste's death, Burke purchased items tied to the handling and concealment of her remains. They allege purchases under a fake name. They allege items delivered to his home. They allege physical evidence from the garage matched Celeste. They allege blue plastic fragments matched an item tied to the case. They allege the Tesla later contained her remains. To the public, that sounds overwhelming. To the defense, it creates a narrow legal question. Even if some evidence connects Burke to what happened after death, does it prove he caused death? That distinction could become the defense's strongest lane. Mutilation of human remains is one charge. Murder is another. The state must prove both. The defense may argue that evidence of panic, concealment, or post-death handling does not automatically prove who inflicted the fatal injuries. That is not an emotional argument. It is a legal one, and it may shape the entire case. The prosecution will likely respond with the full pattern. They will not ask the court to look at the Tesla alone. They will not ask the court to look at purchases alone. They will not ask the court to look at the autopsy alone. They will say, all of it fits together. The alleged relationship, the alleged threat, the final ride, the arrival at the home, the messages after arrival, the lack of emergency call, the late to night travel, the purchases, the garage evidence, the Tesla, the passport discovered, the digital trail. The prosecution's strength is not one fact. It is the chain. The defense's job is to break that chain, one link at a time. The prosecution says Celeste arrived at Burke's Hollywood Hills home on April 23rd. They say Burke ordered the ride. They say she was dropped off at the home. They say she was not seen alive again. That ride record, if proven, could be one of the clearest parts of the prosecution timeline. But the defense may still ask questions. Who ordered the ride? Was it Burke directly? Was it from his device? Was it from his account? Was there any possibility someone else had access? What messages were exchanged before and during the ride? What was the exact drop-off time? What surveillance confirmed she entered? Who else was inside the home? What happened after she arrived? The defense may not be able to deny the ride happened, but it may argue the ride does not prove the killing. It proves arrival, not death. The prosecution will answer that arrival is only one part of the chain. They will say the timing matters. They will say the messages matter. They will say what happened afterward matters. They will say the absence of Celeste after that moment matters. They will say a child entered and never came out. The defense will say the state still must prove what happened inside. That is the core conflict. The messages after Celeste arrived may become another major fight. Prosecutors say Burke sent messages to Celeste, asking where she was after they believe she was already dead. They may argue those messages were fake concern, created to build an alibi. The defense may argue the opposite. They may say those messages show he did not know where she was. They may say if he were pretending. Prosecutors must prove it. They may ask whether the state is reading guilt into messages that could also be read as confusion. This is where timing becomes everything. If Celeste arrived around one time, and messages were sent shortly after, prosecutors must explain why those messages fit their theory. Did her phone stop activity? Did cameras show movement? Did Burke's device move? Did the house have surveillance? Did any witness hear or see anything? Did he call emergency services? Did he leave? Did he drive somewhere? How close is the timeline? How exact is the data? The defense will ask whether the prosecution is filling gaps with assumptions. Prosecutors will argue the gaps are not gaps when all evidence is viewed together. That is the rhythm of the trial. State builds, defense separates. State connects, defense doubts. The Santa Barbara evidence may become another pressure point. Prosecutors allege Burke traveled to Santa Barbara County after Celeste's death. They also say Celeste's passport card was later found in a remote area connected to that route. That sounds significant. A victim's identification found where the defendant allegedly traveled can matter. But the defense may ask whether that connection is exact enough. Where was the passport card found? How was it preserved? Who found it? When was it found? Could it have been placed there at another time? How close was it to Burke's alleged travel route? Does location data show Burke himself there, or only a device? Could the data have a margin of error? Does the trip prove evidence disposal, or does it only prove travel? The prosecution will say the timing and location are not random. The defense will say coincidence, inference, or missing context can create doubt. That is why digital evidence matters so much. The state reportedly has a massive amount of it. Phones, iCloud material, vehicle data, possible surveillance, purchase records, messages, location records, search warrant returns. Digital evidence may become the backbone of the case, but digital evidence is not magic. It still needs interpretation. A phone location places a device, not always a person. A message may show state of mind, but context matters. A cloud file may exist, but ownership and access matter. A purchase may trace to an account, but the defense may question who made it. A timestamp can appear clear, but the defense may question systems and synchronization. That does not mean digital evidence is weak. It can be incredibly powerful. It means the prosecution must explain it clearly, and the defense must find confusion where it can. The large volume of evidence is one reason the preliminary hearing was pushed. The defense needed more time. That delay matters because the defense originally pushed for evidence to come into public view faster. Now, with so much discovery to review, it needs time to prepare. This may look inconsistent from the outside, but legally, it makes sense. A defense team may want a speedy preliminary hearing to force prosecutors to reveal evidence. Once the evidence begins arriving in huge volume, the defense may need more time to read it, test it, send it to experts, and prepare cross-examination. That does not mean the defense is afraid. It means the case is large. The prosecution may not love delay either. Witness memory can fade. Public attention can shift. Evidence issues can become complicated, but prosecutors also want the case to survive. A rushed case can create mistakes. A careful case is harder to attack. That is why the judge's calendar has become part of the tension. The preliminary hearing is not a trial. The prosecution only has to show probable cause. That is a lower standard. The defense may not expect the case to disappear at that stage. Instead, the defense may use the hearing to learn the state's case. Who will testify? Which evidence comes first? How confident are the investigators? How does the medical examiner explain the findings? How does the digital analyst explain the timeline? Do witnesses contradict each other? Are there missing reports? Are there chain of custody issues? Are there immunity deals? Are there statements the defense can later use at trial? A preliminary hearing can be a preview. It can show the defense where to attack later, and that may be exactly why Burke's team pushed for it. Not because it expects the case to vanish, because it wants to see the prosecution's cards. The next defense target is chain of custody. Every physical item in a case must be collected, stored, tested, and documented properly. Blood samples, trace evidence, items from the garage, material from the car, digital devices, delivery records, clothing, any object tied to the case. If the defense finds a weak chain, it may argue contamination, mishandling, or uncertainty. This is common in criminal defense. The defense may not need to prove evidence was planted or corrupted. It may only need to show the handling was imperfect enough to make jurors question it. Who collected the sample? When? Where exactly? Was it photographed? Was it sealed? Who transported it? Who tested it? Were protocols followed? Was there a second test? Were notes complete? Were there gaps? The prosecution will likely be ready. In a case this high profile, prosecutors know chain of custody will be attacked. They will need clean records. They will need experts who explain evidence without confusing jurors. They will need investigators who can defend their work. If they do, chain of custody attacks may fail. If they do not, the defense may find openings. The Tesla creates another major defense lane. Prosecutors say Celeste's remains were found in the front trunk of a Tesla registered to Burke. That fact is central to public attention. But a defense attorney may ask what the car proves about murder. Who had access to the vehicle? Who had keys? Could anyone else move it? Was it always parked in the same place? Who last drove it? What did vehicle data show? What did cameras show? Were there fingerprints? Was there DNA? Did anyone see Burke place anything inside? Was the car accessible to others? The prosecution will likely say surveillance and other evidence show Burke was the last person to drive it before leaving Los Angeles. The defense may ask whether the car was untouched after that. The prosecution may say the full timeline and evidence make any alternative unlikely. The defense may say unlikely is not enough. This is another key trial concept. The prosecution does not need to eliminate every imaginary possibility. It needs to prove guilt beyond reasonable doubt. The defense will try to make any alternative feel reasonable. That could involve suggesting another person had access. But the defense must be careful. Pointing toward another person without evidence can backfire. Jurors may see it as desperation. If the defense has evidence of another person's access, it may use it. If it does not, it may ask questions without naming a full alternative suspect. Who had access? Who was in the home? Who knew where the car was? Who knew about Celeste? Who may have moved items? Those questions can create doubt without making a direct accusation. The prosecution's answer may be simple. The evidence points to Burke. The defense's answer may be just as simple. Pointing is not proving. Another major issue is witness testimony. If prosecutors have witnesses from Burke's circle, the defense will attack them hard, especially if any witness received protection, immunity, or favorable treatment. A cooperating witness can be powerful. They can explain things digital data cannot. They can describe conversations. They can identify people. They can place items. They can explain behavior. But a cooperating witness can also be vulnerable. Why are you testifying? Were you promised anything? Were you afraid of being charged? Did prosecutors offer protection? Did you change your story? Did you lie before? Are you blaming Burke to save yourself? Did you have access to the car? Did you have access to the house? Did you know about Celeste? Those questions can damage credibility. The prosecution will try to support any witness with records, data, and physical evidence. A witness alone can be attacked. A witness backed by phone records, cameras, receipts, and forensic testing becomes harder to dismiss. That is why the prosecution's mountain of evidence matters. It may not rely on one witness. It may use witnesses as one layer in a larger structure. The defense will try to make the structure look unstable. Now comes the sex abuse charge. This may be one of the hardest areas for the defense. If prosecutors have the digital evidence they claim, prosecutors allege an illegal relationship with Celeste while she was underage. They allege messages and digital material support that. They allege Burke had recurring access to her. They allege the relationship was part of the motive. The defense may challenge timing. It may challenge authenticity. It may challenge whether the evidence meets the exact elements of the charge. It may ask who created or sent certain files. It may ask whether Burke knowingly possessed certain material. It may ask whether the prosecution can prove repeated conduct over the required period. But if prosecutors have messages, photos, device data, and travel evidence, This could be difficult for the defense. The defense may then attempt to separate the abuse charge from the murder charge. It may argue that even if jurors believe something illegal happened, they still must separately decide whether Burke caused Celeste's death. That may sound cold, but it is legally important. A jury cannot convict on murder simply because it believes another charge is true. Each charge has elements. Each element must be proven. The prosecution will argue the illegal relationship is not separate. It is motive. They will say Celeste threatened to expose the relationship. They will say Burke killed her to protect his career. They will say the abuse charge and murder charge are connected. The defense will try to loosen that connection. It may say motive evidence is being used to inflame the jury. It may say the state wants jurors angry about one allegation, so they convict on another. That is a standard defense concern. The judge may have to decide how evidence is presented and what instructions jurors receive. Another defense lane is the pregnancy and abortion discussion. Public reporting has said prosecutors referenced messages about pregnancy, abortion, and emergency contraception. But the public record does not confirm Celeste was pregnant. This matters because online discussions can run ahead of evidence. The prosecution may use messages about pregnancy or fear as motive evidence. The defense may argue the messages are being overinterpreted. If pregnancy is not medically confirmed, the defense may say prosecutors cannot present speculation as fact. The safe truth is this: messages may exist. Pregnancy is not confirmed in the public record. That is how it should be presented. The prosecution may not need confirmed pregnancy to argue motive. If the messages show fear, conflict, or pressure, prosecutors may say they matter. The defense may say without confirmation, the state is using emotional material to make jurors assume too much. That is another courtroom fight. The defense may also attack the special circumstances. Special circumstances are what raise the stakes. Murder of a witness, murder for financial gain, lying in wait. Each requires proof beyond the base murder charge. The prosecution must prove not only that Burke killed Celeste, but also that the special circumstance applies. For murder of a witness, prosecutors must connect the killing to preventing testimony or exposure of criminal conduct. For financial gain, they must connect the motive to protecting financial benefit or career value. For lying in wait, they must prove the legal elements tied to concealment, watching, waiting, or surprise. The defense may argue prosecutors overreached. It may say the state charged every severe theory it could, but the evidence cannot support them all. This is where the title angle comes in. Could the defense clear him of the most severe charges? Not because the case is weak, not because the prosecution has no evidence, but because the special circumstances require specific proof. If the defense can weaken motive, timing, or intent, it may attack those enhancements even if the underlying charges remain. That could change sentencing exposure. It could change plea negotiations. It could change how jurors view the case. But right now, it is only a possible defense strategy. Nothing has been decided. The prosecution will likely argue the special circumstances are not extra decoration. They are the heart of the case. Celeste was allegedly a witness to Burke's criminal conduct. Celeste allegedly threatened to expose him. Burke's career allegedly had significant financial value. He allegedly invited her to his home. She allegedly never left alive. That is how prosecutors may connect special circumstances. The defense will say the word allegedly matters. The state must prove every part. The defense may also question the timing of the investigation. Why did charges come when they did? Why were there reports of grand jury proceedings? Why was the medical examiner's report sealed for months? Was there disagreement between agencies? Did investigators initially see the case differently? Was the state slow because it was careful, or because the evidence had gaps? These questions may or may not be allowed at trial. Judges do not allow unlimited speculation about law enforcement disagreements, but if the defense can show inconsistencies in the investigation, it may use them. The prosecution will likely say there was no disagreement that matters. It will say investigators were careful because the case was complex. It will say the body had been found months after death. It will say evidence needed testing. It will say digital records took time. It will say protecting the investigation required restraint. The defense may say delay and secrecy create doubt. The prosecution may say delay and secrecy protected the truth. That is another battle. The public often mistakes delay for weakness. Sometimes it is weakness, sometimes it is caution, sometimes it is both. In this case, the amount of evidence may explain some delay, but the defense may still use the timeline of investigation to ask why the state's theory took shape when it did. Another important point is celebrity. Burke was not an unknown defendant. He was a rising artist with fans, money, and media attention. The prosecution may argue that fame gave motive. The defense may argue fame made him a target. If witnesses disliked him, wanted attention, or feared blame, the defense may say they had reason to point at him. If law enforcement faced public pressure, the defense may say they went after the most visible person. If media coverage became intense, the defense may ask whether the public narrative shaped the case. This is a delicate argument. It can work if backed by evidence. It can fail if it feels like excuse-making. The prosecution will answer that fame did not create the evidence. The Tesla existed. The ride records existed. The purchases existed. The garage evidence existed. The digital records existed. The autopsy existed. The defense will say existence is not meaning. The prosecution will say meaning comes from the chain. Again, everything returns to the chain. That is why this case is so legally interesting. The prosecution may have many pieces. The defense may not need to destroy all of them. It may only need to create uncertainty about the one piece that matters most. Who caused death? That is the headline behind the headline. The public sees the car. The public sees the charges. The public hears about purchases. The public hears about digital evidence. The defense wants the jury to ask one narrower question. Did the state prove David Anthony Burke caused Celeste's fatal injuries? If the jury says yes, the prosecution wins the murder charge. If the jury says no, the case changes dramatically. Even if jurors believe Burke did something wrong after death, the murder charge still requires proof. This is why the defense may choose an uncomfortable strategy. It may admit certain facts. It may decide not to fight every piece of evidence. It may say some actions were wrong, panicked, or criminal, but not murder. This kind of partial admission strategy can be risky. If jurors hear a defendant connected to post-death concealment, they may still infer guilt, but denying everything can be worse if the evidence is too strong. Defense teams often decide which battles are worth fighting. If Amazon purchases are clear, fighting them may damage credibility. If the ride record is clear, denying it may look foolish. If the car registration is clear, pretending otherwise may fail. So the defense may focus on interpretation rather than denial. Yes, the record exists, but what does it prove? Yes, a message was sent, but what does it mean? Yes, a purchase was made, but who made it and why? Yes, evidence was found, but when did it get there? Yes, Celeste was found in the car, but who caused her death? That kind of defense is built around reasonable doubt, not full innocence in the public imagination. But Burke's attorneys have made a stronger public statement. They say he did not murder Celeste and was not the cause of her death. That leaves room for many possible defense paths. One path is total denial. Another path is another person theory. Another path is post-death panic without murder. Another path is attacking forensic certainty. Another path is attacking prosecution motive. Another path is combining all of them. We do not yet know which path they will take. The preliminary hearing may reveal the first signs. The defense may cross-examine the medical examiner hard. It may question investigators about the timeline. It may ask about house access. It may ask about vehicle access. It may ask about digital data. It may ask about witness deals. It may challenge the prosecutor's inferences. It may preserve arguments for trial. The hearing may not clear Burke. It may not even come close, but it may show viewers where the real fight will be. This is where true crime Greyson viewers should pay close attention. Like this video and subscribe to True Crime Greyson if you want careful updates when the preliminary hearing begins. The most important moment may not be the most shocking detail, but the first weak link the defense tries to expose. Now focus on Celeste again. Legal strategy can make a case sound like a game. It is not. A child is gone. Her family is grieving. Her name is tied to evidence no family should ever have to hear discussed in court. Every defense argument exists inside that pain. The defense has a job to do. The prosecution has a job to do. The judge has a job to do. But Celeste's family has to sit through it. They may hear the defense question the autopsy. They may hear the defense question the timeline. They may hear the defense question whether Burke caused death. They may hear language that feels like it reduces their daughter to evidence. That is part of the cruelty of trials. Justice requires testing evidence, but that testing can feel like another injury to the family. The defense can challenge the case. The victim's dignity should not be challenged. Celeste was 14. She deserved protection. Her life mattered before any courtroom argument. The prosecution's theory is painful because it says she was killed for speaking or threatening to speak. If that is proven, then the case is not only about violence, it is about silence. It is about power. It is about a child allegedly becoming dangerous to an adult's public image. It is about fame and secrecy. The defense says that is not what the evidence will show. The courtroom will decide. One of the strongest prosecution answers may be the alleged motive. If prosecutors can show Celeste threatened to expose Burke, and if they can show Burke's career was at a critical point, and if they can connect that threat to the final ride and later evidence, the motive becomes strong. But motive has limits. Motive explains why. It does not prove who. The defense may admit the relationship was tense and still deny murder. It may say threats do not equal killing. It may say arguments do not equal murder. It may say the state is using motive to cover gaps. The prosecution will say motive is only one part. It will point to opportunity. It will point to conduct. It will point to physical evidence. It will point to digital records. It will point to the car. That is the full pattern argument again. The defense may also ask whether any person saw the killing. If not, the case may rely heavily on circumstantial evidence. Circumstantial evidence can be enough, but the defense will remind jurors that they must be sure. Did anyone see Burke cause the fatal injuries? Is there home surveillance? Is there audio? Is there a witness? Is there a confession? Is there a direct admission? If not, prosecutors must rely on surrounding evidence. That surrounding evidence may be strong, but the defense will ask whether it is strong enough. The question of home surveillance could become important. If prosecutors have footage inside or outside the home, the case changes. If they do not, the defense may ask how the state knows what happened inside. Prosecutors may respond with timing and physical evidence. The defense may respond that timing and physical evidence still require inference. The next major defense target is the alleged fake name used for purchases. Prosecutors say items were ordered under a fake name. That can show consciousness of guilt. The defense may ask who had access to the account, who created the name, what payment method was used. Was it Burke's device? Was it his address? Were there other people in the home? Were any of the items used? Were some still unused? If an item was unused, the defense may say it proves nothing. If an item was matched to trace evidence, prosecutors will say it proves a lot. The defense may concede one item, but challenge another. It may say the burn cage, if unused, should not be treated as proof of murder. It may say the shovel, bags, or pool show panic or concealment, not causation. The prosecution will say the items were not random. Their timing, purpose, delivery, and alleged connection to the evidence show planning. The defense will say the state is adding emotional weight to purchases without proving the killing itself. Again, this does not make the defense right. It shows the fight. The sex abuse evidence may be the hardest to keep separate from murder. If prosecutors prove Burke had an illegal sexual relationship with Celeste when she was underage, jurors may feel anger before they even reach the murder evidence. The defense may seek to limit how much of that evidence is shown. It may argue some materials are more prejudicial than necessary. The prosecution will argue the abuse evidence is essential because it explains motive. The judge will have to balance relevance and fairness. In cases involving minors, courts also handle evidence carefully to protect dignity and prevent unnecessary harm. The prosecution may describe rather than show certain material. That matters for the jury and for the public. The case must be proven without exploiting the victim. Another defense strategy may involve expert battles over toxicology. Public reporting has mentioned toxicology findings, but the medical examiner did not list them as the cause of death. The defense may still explore them if there is any room to argue another possible cause or contributing factor. This will be difficult if the official cause is penetrating injuries, but defense attorneys explore every opening. They may ask whether the condition of the remains affected testing. They may ask whether some results were inconclusive. They may ask whether decomposition complicated interpretation. Prosecutors will respond that none of that changes the homicide finding. A jury may not find toxicology persuasive, but the defense does not always need a point to win alone. It may use many small questions to build doubt. The defense may also attack the timeline of contact. After April 23rd, prosecutors say Burke stopped contacting Celeste after a certain point. They may argue that shows he knew she was dead. The defense may ask whether people stopped texting for many reasons. They may ask whether the messages before that show concern. They may ask whether prosecutors are assuming state of mind. The prosecution will likely say when placed beside all other evidence, the pattern becomes clear. Defense says ambiguity. Prosecution says pattern. That is the case in 2 words: ambiguity versus pattern. Now consider the preliminary hearing. The prosecution does not need to show all its evidence. It may choose its cleanest pieces. It may present an investigator who summarizes records. It may present the medical examiner. It may present a digital analyst. It may present a witness who can connect the timeline. The defense may not reveal its full strategy. It may cross-examine enough to preserve issues and learn more. It may hold back its best arguments for trial. That means viewers should not judge the whole case by the preliminary hearing alone. A preliminary hearing is a threshold, not the finish line, but it can still reveal a lot. If the prosecution presents clear, connected evidence, the case will look strong. If witnesses struggle, if timelines blur, if experts concede limitations, the defense may find openings. The judge may still send the case to trial, even if openings exist. But the public will learn where the battle is headed. The defense may also use the hearing to test public pressure. A high-profile case can create assumptions. The defense may want to show that the case is not as simple as the headlines. That is why defense attorneys often speak carefully but forcefully early in a case. They are not only speaking to the judge, they are shaping the future jury pool. They are telling the public, do not decide yet. The prosecution is doing the same. By releasing a detailed theory, prosecutors shape public understanding of motive and evidence. Both sides are telling the public what to watch. The prosecution says watch the full timeline. The defense says watch the proof of causation. That is the best way to understand the next phase. The defense is not trying to make the evidence pleasant. It is trying to make it legally insufficient. Those are different things. A case can be horrifying and still require proof. A defendant can be unpopular and still have rights. A victim can deserve justice and still need the state to meet its burden. That balance is the foundation of criminal law, and it is why this case will be so closely watched, because the facts are emotional. The charges are severe. The accused is famous. The victim was a child. The evidence appears large. The defense is skilled. The outcome is not yet decided. The case may also involve plea discussions at some point. In serious cases, plea talks can happen even when both sides publicly prepare for trial. But if the charges carry life without parole or death eligibility, incentives become complicated. The prosecution may not want to offer a deal that feels too light. The defense may not want to accept a deal that still means decades in prison. The family may have strong feelings. The public may react strongly. The defense may believe it has enough to fight. The prosecution may believe the evidence is too strong to compromise. At this stage, any plea discussion is speculative. The stronger focus is the preliminary hearing. That is the next public test. Now, look at the defense theory in its cleanest form. The prosecution has evidence of a terrible discovery. The prosecution has evidence of alleged concealment. The prosecution has evidence of an alleged illegal relationship. The prosecution has evidence of motive. But the defense will ask whether the prosecution has proof that Burke caused Celeste's fatal injuries. That is the clean defense question. The prosecution's clean answer will be this: the evidence does not stand alone. It all points back to him. The alleged relationship gives motive. The final ride gives opportunity. The messages show consciousness of guilt. The purchases show planning. The garage evidence ties Celeste to the home. The Tesla ties the remains to Burke. The digital records tie movements, communications, and timing together. The autopsy confirms homicide. The defense says the chain breaks. The prosecution says it locks. That is the heart of the story. For a true crime audience, this angle is powerful, because it does not simply ask what happened. It asks what can be proven. That is a more mature question. It keeps the video legally safer. The autopsy is a battle. The ride is a battle. The texts are a battle. The purchases are a battle. The garage is a battle. The Tesla is a battle. The digital evidence is a battle. The witnesses are a battle. The sex abuse charge is a battle. The special circumstances are a battle. And Celeste's family is wading through all of it. That final point must stay. The family did not ask for a legal puzzle. They asked for justice. They did not ask for the internet to argue. They asked for accountability. They did not ask for their daughter's final months to become evidence. They asked for the truth. If the prosecution is right, Celeste was silenced because she threatened to expose something. If the defense is right, the state has blamed Burke for a death it cannot prove he caused. Those are two very different possibilities. The court must decide which one the evidence supports. Until then, the public should avoid two mistakes. The first mistake is declaring Burke guilty before trial. The second mistake is pretending the allegations are not serious. Both are wrong. He is presumed innocent. The charges are grave. Celeste is dead. The family deserves answers. The prosecution must prove the case. The defense must be allowed to challenge it. That is the legal truth. As the preliminary hearing approaches, the biggest question is not whether the public is shocked. The public is already shocked. The biggest question is whether prosecutors can turn shock into proof. Can they prove Burke was the last person with Celeste? Can they prove what happened after she arrived? Can they prove the messages were staged? Can they prove the purchases were part of a plan? Can they prove the garage evidence connects to the homicide? Can they prove the car remained under Burke's control? Can they prove the special circumstances? Can they prove the abuse charge? Can they prove motive beyond speculation? Can they prove causation? That last question is the one the defense wants ringing in every juror's mind. Causation, not suspicion, not horror, not celebrity, not internet outrage. Causation. Did David Anthony Burke cause the death of Celeste Rivas Hernandez? If prosecutors prove that, the defense strategy collapses. If the defense creates doubt there, the case changes. The hearing may start with probable cause, but the real battle is already larger. The defense is preparing for trial. The prosecution is preparing to defend every link. The public is preparing for more details. Celeste's family is preparing to hear painful evidence again. And somewhere beneath every legal argument is one truth no defense strategy can erase. A 14-year-old girl is gone. Her name was Celeste Rivas Hernandez. She should not be remembered only for how she died. She should be remembered because she lived, because she had a family, because she had a future, because she deserved protection. Because no matter what the court decides about Burke, her life mattered before this case ever had a title. That is why the strongest coverage should stay careful, not soft, not vague, careful. Careful enough to say Burke is presumed innocent. Careful enough to say prosecutors allege. Careful enough to say the defense denies. Careful enough to say pregnancy is not confirmed. Careful enough to say uncharged people should not be accused. Careful enough to avoid turning evidence into spectacle. And careful enough to keep Celeste at the center. The next courtroom date could reveal whether the defense has real openings or only legal theory. It could show whether the prosecution's evidence is as connected as the court filings suggest. It could show whether the autopsy is firm under questioning. It could show whether the digital record is clear. It could show whether witnesses are strong. It could show whether the defense can separate concealment from murder. Or it could show the opposite. that the prosecution's chain is stronger than the defense can break. Either way, this case is far from over, and when it moves, the details will matter. If you want more fact-based updates as the d4vd case heads toward the preliminary hearing, like this video, share your thoughts below, and subscribe to True Crime Greyson. We will keep following the evidence, the defense strategy, the prosecution's timeline, and the fight for justice for Celeste.